So the Supreme Court has ruled that the White House can pressure social media companies to remove content that may contain disinformation. The case in question dealt with the Biden administration's decision to do that during the COVID-19 pandemic. In a 6-3 decision, the justices said the plaintiffs who brought the lawsuit didn't have legal standing. CBS News legal contributor and professor at Loyola Law School, Jessica Levinson, knows all about legal standing and just about everything else you could wonder about the legal system. She's joined us now to help us understand this decision a bit more. Jessica, the Supreme Court decided not to focus on the First Amendment argument brought forth in the case. Can you explain why they sidestepped that, and if because they did that, this sets any precedent for online moderation?
Great question. Basically, what the court said is you don't get to come into the courthouse doors. We're not hearing your First Amendment claim here because you didn't pass the initial threshold of showing me that you have an injury in fact that was caused by the government. So with respect to the private people who sued and said, I was kicked off of Facebook or other social media platforms, or the states that sued and said, the Biden administration pressured me into, or excuse me, impermissibly pressured these social media platforms into making certain content moderation decisions. What the court said here with Justice Barrett and the majority is you can't link any alleged injury to government action. And so you're not the right people to bring this claim. So it's really interesting in the sense that this case was supposed to be a fairly big First Amendment case, but I'm not going to teach it in my First Amendment class. I'll teach it in my constitutional law class about what you need to show in order to prove standing. So in terms of precedent, it doesn't answer that big question of how much can a government entity, in this case, a presidential administration, say to, for instance, Facebook during a pandemic, I really want you to take these steps when it comes to content on your platform.
And that's even more significant as we continue in this election year with such a big presidential election in November. I want to ask you about the other big decision. The Supreme Court handed down this morning a decision related to what really counts as bribes for public officials. What are your takeaways from that ruling?
This is a fascinating case that was analyzing the federal bribery statute known as 666. And what the court said is that bribery doesn't include gratuities, meaning payments after the fact where there was no agreement prior to somebody taking a government action that they would get paid. So basically what the court's saying here is a thank you is not bribery. In this case, we were talking about a small mayor in the Midwest. He gave a certain entity basically contracts to do garbage collection. And he then fell on hard times and he said to that entity, I need some money. They paid him after the fact, after they got the government contracts. And what the court said is there was no agreement to give the government contracts to later get the money. That was something separate that happened, really. And the court talked about this, just like taking a teacher out to the Cheesecake Factory. It was an after the fact thank you. That's not what the bribery statute prohibits.
Fascinating development there. Jessica Levinson, always great to have you on. Thanks so much.
Thank you.